Important development in the Supreme Court, where the centre has filed a fresh affidavit before the court defending its law criminalising triple talaq. Remember, this law had been passed by Parliament in 2019. The centre has said that setting aside of the triple talaq in one sitting practice by the Supreme Court in 2017 did not work as a sufficient deterrent. Divorce by triple talaq was still being reported from different parts of the country, and the law was brought in to protect the rights of married Muslim women. Let me go across to Harish now for more on this. Harish, in February this year, the Supreme Court had basically combined a bunch of petitions that had challenged this particular law that had been passed by Parliament in 2019, which criminalised the practice of triple talaq in one sitting. Is that what the centre is now responding to in this fresh affidavit?
Yes, in fact, Times Network has just got the details as far as this affidavit is concerned. In fact, this very important affidavit comes 5.5 years after this Supreme Court had declared triple talaq as unconstitutional, arbitrary, gender discriminatory, especially as it makes suffers a lot of women, and also now this law has been challenged by these several Muslim groups, saying that there is no provision for as far as protection of women and maintenance is concerned. But and also the then Law Minister Ravi Shankar Prasad has said that in the absence of a penal provision, a criminal provision, there were around 500 triple talaqs in 6 months, even after this Supreme Court's ban on triple talaq. So there needed to be a law which penalized triple talaq, a criminal provision. And in this very important affidavit, let me read out for the benefit of the viewers. The Supreme Court, the centre has said,
right.
Centre says, setting aside of
you've accessed the operative portions for us, and let me in fact go across to Amita, who will now read us what's been written or submitted rather by the government in its affidavit before the Supreme Court in this pressing matter. Yes, Amita.
Right, Siddharth. As far as what Harish was pointing out, I'm just going to quickly put that across as a document that he sent across, which says that the petitioner has filed this writ petition with a prayer before the court that the issuance of this writ order, direction and nature of mandamus declaring the Muslim Women Protection of Rights on Marriage Act 2019 as unconstitutional and violative of Article 14, 15, 21 and 123 of the Constitution of India. It is submitted that in this cantina of decisions, this court, while considering the validity of the legislation, has time and again held that the legislation passed by the Parliament can be set aside on constitutionally recognized ground, namely grounds of legislative competence, and whether the legislation is ultra vires when it comes to the provisions of the Constitution or on the same violates the fundamental rights or any other provisions of the Constitution. And at the outset, it is submitted that the impunged act provides the practice of talaq-e-biddat, which is set aside by the Constitution bench of this honorable court. Sure. This is what the matter has now been taken up as far as in this affidavit is concerned.
Right. Thanks a lot for that, Amita. Talaq-e-biddat is, of course, the practice of triple talaq in one sitting, which has been outlawed by that particular law and criminalized as well.